Hello, this is Jonathan Riley of Lawrence Graham, welcoming you to our webinar, which today is our annual commercial law update, looking back at the significant events of 2011. This webinar is being presented by Lawrence Graham's Commerce and Technology Group as part of our SmartLaw programme, and I'm joined today by my colleagues and fellow group members Alex Beale and Ed Cooper. There's one change to our schedule, which is that James Sidwell is involved in a court hearing at the moment and so isn't able to join us to talk about contract rectification. But we still have plenty of other things to review over the next hour. The format for today is that we will have 4 presentations, each of somewhere between 10 and 15 minutes, and then we'll conclude with a Q&A session and aim to close in around an hour's time. You'll see from the slide on your screens at the moment that there's a dialogue box for you to submit any questions at any time during the presentations. We'll receive and collate those questions and then discuss the most popular questions and issues raised in the Q&A session at the end of the presentations. I would add that we have just over 100 participants registered for this session, and so I apologise in advance if we haven't addressed all the questions sent in by the end of the Q&A session. Now I'm pleased to start our presentations by introducing Ed Cooper to discuss a duty of good faith in contracting in the light of the recent Horn and commercial acceptances cases. Ed.
Thank you, John. The topic of this presentation is in relation to obligations of good faith regarding contractual agreements. Good faith has been a notoriously murky concept, and it has always been a controversial question as to how much of it should be allowed to surface in commercial bargains. In addressing this topic, I shall briefly set out the current general position and then look at the development of the court's interpretation of such a principle. In doing so, I shall focus on the very recent case of Horn and Commercial Acceptances Limited and conclude by highlighting the implications of such a decision. Unlike US law and many continental European jurisdictions, the general position under English law has been fairly resolute in affirming that there is no general implied duty of good faith. This meaning that there is no general duty of good faith owed in the performance of contracts and no general duty of good faith owed in the negotiation of contracts, a point which I shall address briefly towards the end of this presentation. The benefit for adopting such an approach is that it ensures a substantial degree of certainty in commercial transactions, in that contracting parties can specify their mutual obligations in detail and be confident that they will be enforced as they are stated. Nonetheless, good faith principles appear in pockets of English law, and as such insurance law, and at times the courts have resorted to interpretive techniques and doctrines of implied terms to ensure that justice and fairness result. Such an approach can be summarised by Lord Justice Bingham's quote in Interphoto and Stiletto, which is that English law has characteristically committed itself to no such overriding principle of good faith, but has developed piecemeal solutions in response to demonstrated problems of unfairness. However, the introduction of various European legislation and the decisions of the courts in recent cases have increased the significance of terms which impose a duty of good faith. As stated, although there generally is no implied term of good faith, this does not prevent parties from contractually agreeing to abide by a duty of good faith by incorporating it as an express contractual term. There has been relatively little guidance from the courts on the interpretation of such express contractual terms requiring a duty of good faith. However, from the cases that have addressed the interpretation of such clauses, we can conclude that the meaning or standard of good faith would include a concept of fair dealing, a requirement to adhere to the general spirit of the contract or the common purpose of the contract, and for the standard of good faith to be assessed in context of the expectations of the parties. Such principles have been cited in Berkeley Community Village and Pulham, where it was stated that good faith amounted to observing reasonable commercial standards of fair dealing, and also requiring faithfulness to the agreed common purpose and consistency with the justified expectations of the other party. In 2010, further guidance was provided in Gold Group Properties Limited, where it stated that good faith would not override express contractual rights, and that good faith, whilst requiring the parties to act in a way that will allow both parties to enjoy the anticipated benefits of the contract, does not require either party to give up a freely negotiated advantage clearly embedded in the contract. Moving on now to the main case study and focus of the presentation. Horn and Commercial Acceptances Limited was recently decided, which further touched upon the concept of contractually agreed duties of good faith In this case, commercial acceptances were in the business of providing finance, principally as loans for real estate. Mr. Trevor Horn was in the music business and incidentally was the lead singer of a band called the Buggles, whose most famous song was "The Video Killed the Radio Star." Mr. Horn is the gentleman on the left. Clearly Mr. Horn made a lot of money from the royalties as he was able to offer supplementary financing alongside commercial acceptances as loans. In this case, commercial acceptances offered a loan to a third party in relation to the purchase of 4 flats on Kingsway in London, on the back of a valuation made in 2006 of over £2.5 million. As agreed between the defendant, commercial acceptances, and the claimant, Mr. Horn, commercial acceptances would provide to the purchaser the first tier of the financing, amounting to approximately 75% of the 2006 valuation. Mr. Horn then agreed with commercial acceptances that he would provide an additional 10% of the valuation, which enabled commercial acceptances to offer a total of 85% of the 2006 valuation to the purchaser, and thereby permitting it to charge a greater rate of interest. Under the agreement between commercial acceptances and Mr. Horn, it was agreed that commercial acceptances would be paid first on any realisation, and therefore Mr. Horn would effectively take the riskiest part of the lending. The remaining funding for the properties came from the purchasers. However, unknown to Mr. Horn, commercial acceptances only put in 50% of the money it had promised, with the remaining 50% of commercial acceptances' commitment being paid by another party, Mr. Goldstein. Such an arrangement was innocent and without any dishonesty or deception, but crucially, Mr. Horn was not notified. Unfortunately, the purchasers defaulted, and due to the recent downturn in the housing market, the value of the property fell by almost 30%, and as a result, insufficient sums were realised to pay off commercial acceptances, Mr. Goldstein and Mr. Horn in full. Consequently, commercial acceptances took the realised funds from the sale of the properties, paying themselves and Mr. Goldstein first, and then transferring the remaining amount to Mr. Horn, a sum which was not sufficient to cover his initial loaned amount. The judge decided the case in favour of Mr. Horn on the basis that the agreement stated that commercial acceptances would be paid first, and then Mr. Horn. There was no mention of a third party in the agreement between commercial acceptances and Mr. Horn, so there was no reason for Mr. Goldstein to be paid ahead of Mr. Horn. However, the point of greatest significance in the case was that the agreement contained a clause stating, "Each party shall act in absolute good faith towards each other." On this point, the judge decided that a failure to reveal the third-party investor was a breach of good faith, and the duty of good faith imposed an obligation to disclose material facts. Furthermore, it was not relevant whether the decision to disclose to the third party would have changed the outcome in practice. The point was that Mr. Horn should have had the ability to choose whether or not to enter into the agreement based on all the material facts. The fact that commercial acceptances were unwilling to fund all of their commitment could have indicated that the loan was not a sound investment. Crucially, it was also said that, in order to determine a breach of good faith, dishonesty was not a prerequisite, nor was there a necessity to find an intention to act in bad faith. Turning now to look briefly at the position relating to the negotiation rather than the performance of a contract. As stated earlier, there is no general duty for parties to negotiate in good faith. In Walford and Miles, it was stated that an obligation to negotiate in good faith was fundamentally incompatible with the principle that each party must be free to advance its own interests in negotiations, and that it would be too difficult to assess damages for a breach of such obligation where the outcome of the negotiations cannot be foreseen. This approach has been affirmed in subsequent cases and is widely accepted as a general position. However, the Court of Appeal case Petromec Inc. and Petrolio Brasileiro distinguished the case from the general approach in Walford. It was stated as obiter dictum that an express contractual provision to negotiate in good faith was not unenforceable, and that the fact that it would be difficult to determine whether action had been taken in good or bad faith ought not to prevent a court from enforcing such an obligation. Although obiter, it would appear that following Petromec, an obligation to negotiate in good faith may be enforceable if first, the obligation is express, secondly, the obligation is part of a contractually binding agreement, And finally, the matter to be negotiated is capable of objective assessment by a third party. However, this certainly is the exception to the rule, and ultimately each decision will be highly dependent on the particular facts of the case. So what are the conclusions to be drawn? There is still no general implied duty of good faith in English law. However, this does not prevent parties from expressly agreeing to be bound by such a duty. The guidance from the court on the interpretation of an express contractual duty of good faith remains the same. However, following Horn and commercial acceptances, we can add that dishonesty or bad faith is not a prerequisite for determining a breach of such a duty. In practice, when negotiating contracts, there should be caution before accepting a contractual obligation of good faith, or at least awareness of the potential effect of such a provision. It is very easy for a reference to good faith to be included as a recital at the start of the agreement and thereafter be incorporated as a term. Finally, and to conclude this presentation, when performing under a contract which includes a duty to act in good faith, extra care should be taken to assess whether any material facts should be disclosed before entering into the contract or during the term of the contract. Thank you.
Thanks very much, Ed. Thanks for that. For our second presentation today, I'm going to look at the meaning of reasonable endeavours and best endeavours and the differences between them, and some practical considerations on the use of those expressions arising from the 2011 case of Jet2.com and Blackpool Airport.